Default. Default is the failure of the defendant to answer within the proper period. The rules provide that the defendant shall file his answer to the complaint within 15 days after service of summons unless a different period is fixed by the court. When the defendant is served with the summons and a copy of the complaint, he or she is required to answer within 15 days from the day he or she was served with the summons. The defendant may also move to dismiss the complaint within the time for but before the filing of the answer. The court held that 15 days is sufficient time for a defendant to answer with good defenses against the plaintiff's allegations in the complaint. Thus, a defendant who fails to answer within 15 days from service of summons either presents no defenses against the plaintiff's allegations in the complaint or was prevented from filing his or her answer within the required period due to fraud, accident, mistake, or excusable negligence. In either case, the court may declare the defendant in default on motion by the plaintiff and notice to the defendant. The court shall then try the case until judgment without defendant's participation and grant the plaintiff such relief as his or her complaint may warrant. The effect of a defendant's failure to file an answer within the time allowed is primarily governed by Section 3, Rule 9 of the Rules of Court, which provides that if the defending party fails to answer within the time allowed, therefore, look at the illustration, the court shall, upon motion of the claiming party, with notice to the defending party and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment, granting the claimant such relief as his pleading may warrant, unless the court in its discretion requires the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. The elements of a valid declaration of default are, number 1, the court has validly acquired jurisdiction over the person of the defending party, either by service of summons or voluntary appearance. Number 2, the defending party failed to file the answer within the time allowed therefore. And number 3, a motion to declare the defending party in default has been filed by the claiming party with notice to the defending party. These elements are the underlying circumstances before there can be a declaration of default. However, even if the defending party fails to file an answer, but there is no motion on the part of the claiming party, there can be no declaration of default. Okay? Where there is no motion, there can be no declaration of default. And a motion is one of the requirements for a valid declaration of default. Okay, the requirements that must be complied with before the court can declare the defending party in default are, number 1, the claiming party must file a motion asking the court to declare the defending party in default. Number 2, the defending party must be notified of the motion to declare him in default. And number 3, the claiming party must prove that the defending party has failed to answer within the period provided by the rules of court. Question: can declaration of default be possible despite invalid service of summons? The Supreme Court answered in the affirmative. The court held in one case that we upheld the trial court's order declaring petitioner in default despite the invalid service of summons upon it. In that case, respondent moved to declare the defendant in default due to the latter's failure to file its responsive pleading despite receipt of the summons. Acting on the plaintiff's motion, the trial court declared the defendant in default. In affirming the validity of the default order, the Supreme Court took note that the trial court acquired jurisdiction over the defendant due to its voluntary submission to the jurisdiction of the court by filing numerous pleadings seeking affirmative relief and not on the strength of the invalidly served summons. Okay, so remember that jurisdiction over the defendant may be acquired through valid service of summons or voluntary submission. In this case, it was voluntary submission. So even if there was invalid service of summons and the defendant actually voluntarily submitted himself to the jurisdiction of the court, then a default declaration may still be possible. Okay. There can be no motu proprio declaration of default. The rule on default requires the filing of a motion and notice of such motion to the defending party. It is not enough that the defendant fails to answer the complaint within the reglementary period. The trial court cannot motu proprio declare a defendant in default, as the rules leave it up to the claiming party to protect his or its interests. The trial court should not under any circumstances act as counsel of the claiming party. Now, where there is no default declaration, answer may be admitted even if filed out of time. It is within the sound discretion of the trial court to permit the defendant to file his answer and to be heard on the merits even after the reglementary period for filing the answer expires. The rules of court provides for discretion on the part of the trial court not only to extend the time for filing an answer, but also to allow an answer to be filed after the reglementary period. The Supreme Court held in the case of Spouses Lomanes versus Sablas that the rule is that the defendant's answer should be admitted where it is filed before a declaration of default and no prejudice is caused to the plaintiff. Where the answer is filed beyond the reglementary period but before the defendant is declared in default and there is no showing that defendant intends to delay the case, the answer should be admitted. Now, when an answer is filed, there can be no more declaration of default. The policy of the law has been to have every litigated case tried on the merits. As a consequence, the courts have generally looked upon a default judgment with disfavor because it is in violation of the right of a defending party to be heard. A default judgment does not pretend to be based upon the merits of the controversy. Its existence is justified on the ground that it is the one final expedient to induce defendant to join issue upon the allegations tendered by the plaintiff and to do so without unnecessary delay. A judgment by default may amount to a positive and considerable injustice to the defendant, and the possibility of such serious consequences necessitates a careful examination of the grounds upon which the defendant asks that it be set aside. In implementation of the policy against defaults, the courts have admitted answers filed beyond the reglementary periods but before the declaration of default. Okay, as I've mentioned, where an answer has been filed, there can be no declaration of default anymore. In another case, the court exercised its discretion not to admit the answer even before the declaration of default. The court held that it is true that the RTC had the discretion to permit the filing of the answer even beyond the reglementary period, or to refuse to set aside the default order where it finds no justification for the delay in the filing of the answer. Conformably with the judicious exercise of such discretion, the RTC could then have admitted the belated answer of the petitioner and lifted the order of default instead of striking the answer from the records. However, the RTC opted not to condone the inordinate delay taken by the petitioner and went on to render the default judgment on August 23, 1999. The Supreme Court held that such actions were fully within its discretion. The court upheld the default. While the courts should avoid orders of default and should be, as a rule, liberal in setting aside orders of default, they could not ignore the abuse of procedural rules by litigants like the petitioner in that case, who only had themselves to blame. Okay? So whether or not to allow an answer to be filed after the reglementary period and before the declaration of default is within the discretion of the court. Interruption of the running of the period to answer. The period to file an answer is interrupted by the filing of a motion to dismiss or the filing of a motion for a bill of particulars. The defendant may not be declared in default while any of these motions remains pending and undisposed of. The period to file answer will run again from the moment defendant receives the order denying any of these motions. In one case, the Supreme Court ruled, apart from opposing defendant's motion to dismiss, Plaintiff Garcia asked to declare Narciso in default for not filing an answer, altogether disregarding the suspension of the running of the period for filing such an answer during the pendency of the motion to dismiss that she filed in the case. Consequently, when the trial court granted Garcia's prayer and simultaneously denied Narciso's motion to dismiss and declared her in default, it committed serious error. Narciso was not yet in default when the trial court denied her motion to dismiss. She still had at least 5 days within which to file her answer to the complaint. What is more, Narciso had the right to file a motion for reconsideration of the trial court's order denying her motion to dismiss. No rule prohibits the filing of such a motion for reconsideration. Only after the trial court shall have denied it does Narciso become bound to file her answer to Garcia's complaint. And only if she did not do so was Garcia entitled to have her declared in default. A defendant declared in default loses his or her standing in court. He or she is deprived of the right to take part in the trial and forfeits his or her rights as a party litigant. He has no right to present evidence supporting his or her allegations, and has no right to control the proceedings or cross-examine witnesses. Moreover, he or she has no right to expect that the court would act upon his or her pleadings, or that he or she may oppose motions filed against him or her. A party declared in default does not waive all of his or her rights, okay? He or she still has the right to receive notice of subsequent proceedings. Also, the plaintiff must still present evidence supporting his or her allegations despite the default of the defendant. The effect of order of default under the rules is that a party in default shall be entitled to notice of subsequent proceedings, but not to take part in the trial. Effect of an order of default. The court shall proceed to render judgment granting the claimant such relief as his pleading may warrant, or, in its discretion, the court shall require the claimant to submit evidence. Okay, now, what is the remedy if the motion to declare the defendant in default is denied? The court held in one case that when the trial court denied petitioner's motion to declare respondent in default, petitioners questioned the court's order by filing a petition for certiorari under Rule 65 with the Court of Appeals. The Supreme Court held that any error imputable to the trial court in not declaring a defendant in default can be reviewed in an appeal from the final decision on the merits of the case. If every error committed by the trial court were to be a proper object of review by certiorari, the trial court would never come to an end, and the appellate court's dockets would be clogged ad infinitum with the aggrieved parties litigants filing petitions against every interlocutory order of the trial court. Okay? Such a situation could only undermine the proper conduct of litigation before the courts and ought not to be tolerated if we are to enhance the prompt administration of justice at every level of the judicial hierarchy.